Hello, and a warm welcome back. Well, it's been a long and interesting road on the way to this, the concluding part of our 7-part series. If you've been with me every step of the way, many thanks. On the other hand, if you're tuning in for the first time to this part, a very warm welcome. This is a fine place to start, and there's nothing to stop you from working backwards later. Through to this point in this series, we have broad and deep social context, we have social science and gaps therein, we have policy, and we have a tiny dash of admittedly rather sour politics. But now in this segment, it's time to bring out the biggest and the most powerful guns of all, namely our Constitution and our fundamental political values as a Western liberal democracy. These are aspects that are not in our daily lives, always visible to our conscious awareness. However, when we pause to read the international section of a good newspaper, we become aware of the many profound advantages we have as members of our society, and hopefully with the benefit of some insight, we attribute many of those advantages to the dignified political order that we are indeed so privileged to enjoy. This is a political order that has been established by many luminaries in our political history. And those authors of our Constitution and of our core political values, have stood on the shoulders of many profoundly wise and insightful thinkers and theorists, who themselves have been steeped in a tradition of Western liberal thought that extends back centuries. And we need to remind ourselves, if we come up even briefly for air from our busy daily lives, and we look at the absolute chaos that today afflicts so much of the world, and not so long ago afflicted even parts of what is now the developed world, that it is extremely easy to screw it all up. It is easy in just a few years to subvert a painstakingly constructed constitutional order and turn it upside down, often with the very best of intentions. The lesson of this part 7 is that one of the prices of living in a constitutional democracy is to remain conscious of what that constitution is, what it requires, and especially of the dignity that it invests in all of us as individuals. And also to spare a thought for the basic rules of the game, what it is permissible to assert in a liberal political discourse versus what is the equivalent of running offside. Although there are referees, even as an involved spectators, our lives are more meaningful and more secure if we follow the play in this game closely. The other price, when circumstances demand, is that we be prepared to rise from our stupor and the distractions of our daily lives, to stand and find meaningful and civil ways to express our concerns and to ensure that we are heard. I myself have not for many years been involved in politics in any shape or form, but I'll tell you, this issue has channeled my consciousness and my energy like nothing before in my life. Every waking breath for weeks. I am deeply concerned about what this portends for our political society in Canada. And so, without too much further ado, let me explain to you exactly why I'm concerned. In a word, the proposed legislation violates important charter guarantees of liberty, freedom of the press, and freedom of expression. The stated purposes of Bill C-36 do not justify these infringements. The moral touchstones contained within the preamble are inadmissible as public reasons within a political debate. They are vacuous ethically, and they feature circular reasoning. The provisions of Bill C-36 fail the test of minimal impairment in that they pass over much less intrusive and more effective alternative approaches, for example, what we outline in Part 6, for the only legitimate purposes of this policy. It is not a good sign that Parliament is even putting this before the public of Canada, because it is obliged to defend fundamental rights and freedoms in this country, even when doing so requires contravening majority opinion. Many Canadians are going to want to continue to express poignant and effective messages in this debate and to pledge themselves to acting politically on their convictions. Before we're done in this segment, we'll outline a wide variety of reasonable amendments and a pledge and provide focal points for intelligent discourse and mobilization vis-a-vis Bill C-36. Among other crucial liberties, Bill C-36 infringes on freedom of the press in banning classified, banner, and display advertising for sexual services, and also on freedom of expression in contemplating preventing sex workers from expressing in those forums meaningful accounts of their personal qualities and their call for attention and regard from others in this world, partially on that basis. Now, when the government contemplates telling Now Magazine or Georgia Straight Magazine or Backpage that they cannot run a huge category of messages from advertisers, doesn't a little bell go off in their heads and cause them to pause and ask themselves, wait, isn't that freedom of the press? That some women who would advertise through those channels have well-defined and concise expectations that must be met in order to give their consent for sex does not differentiate their instances of expression from the myriad people who similarly post a profile on a dating website such as Plenty of Fish or OkCupid. We can safely assume that those other people also have their own conditions to be met. And we can assert, without further discussion, that no government could deliberately set out to thwart modern routine dating behavior among competent adults in a free and liberal society. Now, even if a simpleton wanted to construe sexual services as a commercial activity, like operating a chain of hotels, expression about those services would still be protected by the Charter of Rights. And that's because meaningful expression, even when it's commercial, is protected under the Charter according to Canadian jurisprudence. As 3 justices of the Supreme Court of Canada stated in a Charter Rights ruling in 1989, even if, quote, the government's purpose was not to restrict free expression, the plaintiff can still claim that the effect of the government's action was to restrict her expression. To make this claim, the plaintiff must at least identify the meaning being conveyed, how it relates to the pursuit of truth, participation in the community, or individual self-fulfillment and human flourishing. Advertising for sexual services in a forum such as Backpage clearly conveys a meaning in the sense that it evokes and celebrates human desire for social and sexual connection, and it expresses some of one's claims for attention in this world. This is not expression akin to choosing your own color for margarine, believe it or not, a separate issue that cropped up in another case, but rather communication about some of the most obvious and important characteristics that people present to one another. Even if a narrow-minded court were to reject that argument, this judgment speaks clearly of participation in the community and individual self-fulfillment and human flourishing, all of which apply to sex workers and clients alike. Sex work is obviously a social activity that relates closely to one's identity and often to honest and forthright communication surrounding that. Turning now to Section 7, Liberty, let me direct a few choice preemptory comments to Canadian members of Parliament and the Cabinet. What part of liberty in our Charter don't you get? When you think of passing laws, the efficient purpose of which is to constrain the daily choices individuals make concerning their sex lives, doesn't another little bell go off in your minds that, gosh, doesn't that seem to be something fundamentally or inherently personal? As you know, those aren't my words. That's the primary Canadian jurisprudence on the term liberty, written by the current Chief Justice of the Supreme Court of Canada. The truth is that it doesn't take much to show that Section 7 clearly establishes a presumptive right to demand and to provide financial support for sex. So step by step in slow motion. A. Liberty must imply, among other things, a right to pursue a sexual life free from interference with other consenting adults. B. To give or withhold one's own consent for sex. C. According to whatsoever implicit or explicit conditions one might consider reasonable, appropriate, or appealing. D. Including the provision by a sex partner of emotional, practical, financial, or any other form of assistance or support. E. And for the sex partner freely to accept or decline in deciding himself whether or not to consent to sex on those terms. I challenge you to find a broken link in that chain. I don't think there is one. Now, a note about C and D. Those conditions can be, and often are in our world, just about anything under the sun. That one be treated with deference and respect. That one be brought breakfast and coffee in bed on Sunday mornings. Be brought roses and champagne on one's birthday, or be given cash in crisp 50s in an envelope. Being a protected liberty, there's a presumption that the state may not set out intentionally to frustrate precisely the protected pattern of conduct. For example, by placing an electric fence around your home to prevent all lovers who would seek to comply with your conditions from presenting themselves. Sex, much like artistic expression, is inherently a social action, and the right to consent to sex on one's own terms that we've established very quickly here therefore pertains to the line segment, in geometrical terms, that connects a bearer of rights with another person. And that is a line that is not to be erased or deliberately rendered difficult to establish at either end of the line without very good reason. So Section 7 of the Charter establishes a crystal clear presumption that one can engage in what is grandiosely termed in Bill C-36 sexual services for consideration, but what is, in the real world, merely sex in which consent is subject to conditions of a kind that are extremely common in human life. You'll recall that the ubiquity of such conditions was the theme of the very long Part 4 of this series. So we've arrived very quickly at the need to settle this with something called the Oakes test to determine whether these surprising and absolutely naked infringements of core charter liberties could possibly find some overriding justification in this one special instance. And this will require that we examine closely the declared purposes of the legislation, especially those articulated in the preamble to the legislation itself. But I'll give you a sneak preview. When we study them closely, the goals defined in the preamble to this legislation are most curious. They set out several fancy words that, to a great extent, are aspersions cast on the whole class of liberties that we've just established are clearly protected. As we'll soon argue, upon inspection, they appear to be vague and coded declamations of features integral to precisely the same activities, and as such. It's as if a ruler in a constitutional monarchy in an entirely different context sought to justify infringing freedom of expression by ascribing in a preamble a special value to silence. Whereas I, the philosopher king, do declare that silence is golden, at the top of a new ordinary law that reads, "No one may henceforth utter words beginning with the word S." Breaking the silence is a feature of uttering words with the letter S, a protected liberty. And enjoying and regarding with due relish another person's physical embodiment are features of having sex. So in both instances, we have an attempt by a ruler or a parliament to superimpose a thumbs down in the preamble to ordinary legislation on the thumbs up that is clearly guaranteed by a cornerstone of a constitution. This is an exercise in sleight of hand, and George Orwell had a great word for this. doublespeak. So let's get down immediately to laying all of this out in systematic form. The Oakes test is named for an early Charter of Rights case in which the court first proposed a relationship between Section 1, which potentially provides a government with a sort of get-out-of-jail-free card for breaching charter rights, and the remainder of the Charter. Basically, it says when that get-out-of-jail-free card is or is not valid. In that case, the justices made clear that the Charter is no pushover. You need to have very robust justifications for infringing on charter rights and freedoms. Of course, they had a point because otherwise the Charter would hardly be worth the paper that it's written on. Now, for the sake of keeping this presentation moving, so that I can take a vacation the moment it's released, our argument will pertain only to the two little boxes shaded in gold. And to save even more time, we'll dispense with the minimal impairment question, the middle of the lower tier, right here, right now. What minimal impairment means is you can't go slashing and burning when you could have used a pair of hedge trimmers instead, done a much tidier job with much less or no collateral damage to rights. So you can see the test results, so to speak, for minimal impairment for Bill C-36 by going back to the full policy discussion in Part 6. There we established that a much, much lighter touch policy achieves the legitimate purposes of the non-redundant portions of this legislation pertaining to the welfare of consenting, competent adult sex workers. Given that so much of the policy, as currently framed, is actually counterproductive, flying far wide of the mark, as we saw, the failure of Bill C-36 on the minimal impairment test should be apparent to all. Now that, of course, does presume that the only legitimate purpose of this legislation is to reduce the harm done to the workers who choose to make their living in this field. But is that the only legitimate purpose? Well, yes, recognizing that there is a significant amount of deadwood that now needs to be cleared out from the preamble. And that gardening exercise, obviously good organic gardening, is precisely what we need to do now. And with that in mind, we're going to focus specifically on the objectives, and as in the little upper left box of this chart, consider to what extent they are substantial and pressing. As it turns out, not only are those goals not substantial, as we'll see a little later, they're not coherent or even remotely admissible in a modern, plural, liberal democracy. Section 1 of the Charter says we live in a free and democratic society. And what does free mean, if not a respect for pluralism, and in particular that the government avoid invoking certain reasons for infringing individual liberties? So with some help from Peter de Marneff in an excellent book published by Oxford University Press in 2010, let's tick off some examples of reasons that a liberal democratic state shall never invoke to limit individual liberties and freedoms. And all of these are a quote. A person's conception of a good life is false or contains false propositions about what is good or valuable. Or, by expressing some belief or attitude, a person makes it more likely that someone else will form a false evaluative belief about how best to live. Or, by pursuing a goal or by engaging in an activity, a person will not develop and exercise her higher human capacities as fully as possible throughout her life, or as fully as she might have. Or, what a person wishes to do is intrinsically wrong or bad, or wrong or bad independent of its negative effects on anyone. Or, the goals a person wishes to pursue or the activities she wishes to engage in are inherently worthless. Or, others disapprove of the goals a person wishes to pursue or the activities she wishes to engage in. Or finally, by doing something a person fails to treat with due care or respect something precious, such as the capacity for sexual intimacy, or sacred, such as potential human life. Now, let me hasten to add that if you're a priest, an imam, or a rabbi, you feel free to go wild with this stuff. If you've got someone sitting there in your congregation on one of those hard benches, you tell them. And as parents, occasionally we will be using some of these statements as templates for expressing our values to our children. All fine and good. It's just that I'm very sorry to say none of these things have any place whatsoever in the laws of a plural, liberal, democratic society. And even in the political discourse, their place needs to be very carefully restricted, because as to the specifics, we just don't and will never agree. And it's generally just a matter of civic courtesy to keep your mouth shut about substantive views about these things in the text of the laws and in the surrounding official political discourse. In the introduction to this segment, I spoke about the luminaries of our Western liberal tradition. Let us turn now for perspective and inspiration in this moment of need to Isaiah Berlin from his beautiful and seminal essay, Two Concepts of Liberty. And I quote, "Pluralism, with a measure of negative liberty that it entails, seems to me a truer and a more humane ideal than the goals of those who seek in the great disciplined authoritarian structures the idea of positive self-mastery by classes or peoples or the whole of mankind. It is truer because it does at least recognize the fact that human goals are many, not all of them commensurable, and in perpetual rivalry with one another. To assume that all values can be graded on one scale, so that it is a mere matter of inspection to determine the highest, seems to me to falsify our knowledge that men are free agents. It is more humane because it does not deprive men, in the name of some remote or incoherent ideal, of much that they've found to be indispensable to their life as unpredictably self-transforming human beings. In the end, men choose between ultimate values. They choose as they do because their life and thought are determined by fundamental moral categories and concepts that are a part of their being and thought and sense of their own identity, part of what makes them human. Any attempt to construe the liberty of the Canadian Charter as the freedom to have one's private life thoroughly reformed by a repressive and intrusive state displays an astounding ignorance of our Western liberal tradition and pluralism. The problems with Bill C-36, and they are extensive, literally start with the preamble. The purposes it lays out are simply incommensurate with our liberal tradition. It problematizes a bunch of complex and ill-defined social phenomena in a sexual context, including exploitation, objectification, commodification, and human dignity. Now, these concerns in this context are precisely what Berlin means by some remote or incoherent ideal on the previous slide. As instances of government moralism, they are as remote and subjective as religious precepts and aesthetic judgments, and they are equally unsuited as the foundations for legislation in any liberal plural society. Canadian citizens absolutely do not have and will never have consensus over these essentialist and abstract premises. We'll try to decode it a little more in a minute, but the preamble, by appearing to imply that the human body is not a fit object in and of itself for holding another person in high esteem, sets out a premise that is contravened in practice by a great many forms of contemporary popular culture. And these can be witnessed on any magazine stand in publications targeting audiences of both genders. The comment about commodification is either circular or it is tendentious and question-begging and merely substitutes a single buzzword for that which must be, at minimum, a long, complex, and highly controversial argument about the essential proper context for human sexuality. Human dignity in this particular context is similarly an ill-defined and unhelpful construct, in that proponents and opponents of this legislation will each argue endlessly concerning whether reducing sexual freedoms respects or hinders dignity. All these terms need to be strictly avoided as the basis for legislation on any subject in a Western liberal society such as Canada. Let us now amplify this point with the wisdom of the eminent late political theorist, John Rawls. Rawls argued that assertions of even secular philosophical doctrine are generally out of bounds within the political domain. He develops a concept of public reason. Quoting freely from him, he argues that no citizen or association of citizens should have the right to use state power to decide constitutional essentials as that person's or that association's comprehensive doctrine directs. Rather, what he calls a duty of civility requires that the application of substantive principles be guided by judgment and inference, reasons, and evidence that the persons they represent can reasonably be expected to endorse. This precludes reaching beyond plain truths now widely accepted and forms of reasoning found in common sense, together with the methods and conclusions of science when these are not controversial. This means that in discussing constitutional essentials and matters of basic justice, we are not to appeal to comprehensive religious and philosophical doctrines, to what we as individuals or members of associations see as the whole truth. And let us quote a work published in 1997 entitled "The Idea of Public Reason Revisited." A view often expressed is that while religious reasons and sectarian doctrines should not be invoked to justify legislation in a democratic society, sound secular arguments may be. Some think of any argument that is reflective and critical, publicly intelligible, and rational as a secular argument, and they discuss various such arguments for considering, say, homosexual relations unworthy or degrading. Nevertheless, a central feature of political liberalism is that it views all such arguments the same way it views religious ones, and therefore these secular philosophical doctrines do not provide public reasons. Secular concepts and reasoning of this kind belong to first philosophy and moral doctrine and fall outside the domain of the political. Thus, in considering whether to make homosexual relations between citizens criminal offenses, the question is not whether these relations are precluded by a worthy idea of full human good as characterized by a sound philosophical and non-religious view, nor whether those of religious faith regarded as sin, but primarily whether legislative statutes forbidding those relations infringe the civil rights of free and equal democratic citizens. This question calls for a reasonable political conception of justice, specifying those civil rights, which are always a matter of constitutional essentials. It should be abundantly clear that the large set of fancy words that have been chained together to make a big splash in the preamble and in the supporting official political commentary have no place in a plural, liberal, modern democracy. They are so far from fitting within Rawls' concept of public reasons, and their very use is indeed a severe breach of the civic courtesy that is required in public political discourse. And these abstract, complex, and highly controversial concepts are grossly unsuitable to form the basis for restricting basic liberties. Now, having got that off my chest, and to be sporting about it, let's pretend for a moment that the context of this current discussion were something other than it is, which, as you know, is the political argumentation in the public square concerning the severe infringements of this legislation on some of our most basic and guaranteed rights in our society. And let's forget for a moment that we are here pleading to spare many lives that will otherwise be placed at risk by the state turning women back out into the street. And so, for just a few minutes, let's imagine that we were instead to debate at leisure, perhaps in a campus pub, within a university debating society, a graduate seminar, or a faculty club, elements of the preamble purely as moral, ethical propositions. Now, I'm sitting here by myself, and I have no way, literally, to enact this debate. However, what I can do is to show you the notes I would compile in preparation for just such a debate. And how would we organize those notes? Well, first, we would need to decode and disaggregate the bare buzzwords appearing in the grandiose preamble into rational and comprehensible principles susceptible of discussion. I've made a first and admittedly crude attempt in the second column. Here the various bullet points are alternative, in a few cases, complementary renderings of general ethical principles such as might be proposed. This I have found is not an easy task, and I hope that someone else more steeped in the underlying claims can step up and state them in a more promising fashion, because as they stand, they turn out to be, in almost all cases, utterly vacuous ethically. Really, if members of the government understand these terms and their implications, and they wish to promote them, they're going to need to issue some sort of philosophical treatise rather than leaving it to folks like me. In any case, we can observe for these candidate ethical rules a set of difficulties that the various rules would confront. And so in the third column, I've posed these difficulties as questions left unanswered for your reflection. I do hope you immediately see that several parts of this series of presentations directly speak to what is or is not reasonable to assert based on a careful examination of the evidence. For each of these pages, you are of course welcome, in fact invited, to hit the pause button and to read through and reflect deeply on the questions raised at your leisure. You will probably need to be watching this video in 720 high definition in order to read them clearly. This page of notes pertains to the first of the four terms that we'll review, commodification. So what could that term mean expanded into actual ethical injunctions? Well, it could mean do not pay or receive cash for any gestures or actions, including sex, that are sometimes rendered as part of loving communal relationships. Or do not pay or receive cash for sex specifically because it is special and unique among the increasingly commoditized services. Or do not engage in a sexual relationship that is established or sustained by a systematic and unequal pattern of resource transfers from one partner to the other. Now, the first red flag as to difficulties arises even before we get into the detailed injunctions, because this term commodification is awfully close to being a synonym for paid sexual services, and in the popular consciousness probably draws to mind precisely the same social phenomena. So is this a circular argument, being a mere synonym for that which is condemned, ostensibly for this reason? Beyond that, we need to ask, does this argument stand, apart from sex work, also for paid home, elder, disabled care, for spa treatments and in restaurants? And if not, because sex is somehow special to whom? Is it to sex workers or clients or third parties? And if just the latter, what legitimate cause for intervention in the private lives of others do they have? And if third parties are presenting these claims on others, what are their specific grounds and reasons? Are these rules suited to an atomizing, mobile, post-industrial society of the sort that we reviewed in detail in Part 2? And with respect to the wide variety of forms of sex work reviewed in Part 3, does the market relation in paid sex necessarily nullify the opportunity for sharing and personal connection? And if yes, what contrary grounds or evidence for dismissing Bernstein's evidence of bounded authenticity in contemporary forms of sex work? Looking at the consequences, would these rules, if observed, result in positive consequences for human sexuality and wellness. More sex, better sex, improved social distribution of sex, for whom? In greater community social network density across class and race? And perhaps most fundamentally, is prescribing resource transfers in sexual relationships even a prima facie reasonable proposition for the human species? And if you answer yes to that question, please go back and watch part 4 of this series. Next, we come to objectification. And incidentally, in the next 3 slides, I've highlighted in gold any points that actually seem reasonable under these headings. Rather than bore you with my incessant voice, and to preserve it, I'll simply invite you to hit the pause button here and look through this. I'll let it play for just a few seconds and then advance to the next slide. Next, we come to exploitation. And reading just the first of these plausible ethical injunctions, we could interpret exploitation to imply, do not have sex with a competent adult who consents, but is likely, under the circumstances, later to regret having consented. Let me say, for what it's worth, that I do strongly agree with the first item as a moral ethical principle, because I think it's consistent with one of my own personal principles of seeking win-win outcomes in all personal and professional interactions. In part 6, you'll remember we developed and reviewed a 3-part plan intended simultaneously to improve physical security and the degree of meaningful choice and consent in sex work, and thereby, I hope, greatly to reduce the risk of regret. Once again, I'll suggest that you hit the pause button to review the other plausible injunctions and their difficulties, and I'll move on. Finally, we come to dignity. And please read through this, but let me make a few general points. This is an immense concept, and so I have concerns with it being accorded in the preamble anything more than ceremonial weight. As noted separately under the difficulties, there's a grave risk with this term that it sneaks into the rationale considerations that are strictly inadmissible. Let me also highlight, among the ethical injunctions, and comment on what I'll call the proposed do better rule. Do not have sex with someone if you could do better. The do better rule, while undoubtedly popular with parents considering the interests of their children, is hard to generalize into a principle that is clearly in the best interest of society as a whole. Is society actually best served by all members forming social connections or having sex only within their own class or caste or among folks bearing the same level of intelligence? Such assortative mating is actually blamed for a reduction in the degree of upward mobility in modern society. And while it's undoubtedly in the best interest of an individual to do the best they can, in the same sense as it's great for them to select the best possible used car, it's tough to elevate a principle that implies social exclusivity to the status of any important moral principle. Also, there is a genuine and irreducible tension between, as Shakespeare put it, gathering your rosebuds while you may, and holding out for uncertain other prospects. And that applies both over the long term of our lives and on any particular Friday night. And that dilemma is sufficiently familiar to all of us to require no further discussion. Let me observe also, before I move on, that it does seem entirely fair, and indeed at the core of the dignity that we possess as free agents, never to have sex if one believes that doing so would undermine one's self-esteem or make one unwell or unhappy. So where does that leave us? As I expect you'll agree, having studied and reflected upon the individual propositions, they turn out to be, by and large, very disappointing. At the first contact with the oxygen of critical scrutiny, the vast majority of them burst into flames. And although the 4 major terms reviewed from the preamble are impressively multisyllabic and at first consideration make appeals on our consciences, Once broken into plausible, comprehensible, and modest statements, they appear incoherent and to lack moral probity. None of them, even if they were admissible, could lend the substantial and pressing justification envisioned by the Oakes test for laws that violate important freedoms and liberties. That said, as we've seen, it does appear that there are three specific ethical statements that we reviewed that do survive careful reflection and scrutiny as priorities for societies as well as for individuals. In review, the surviving propositions are, under objectification, do not fail to notice and to give credit for the diverse good qualities and capabilities of others, including of sexually attractive persons and casual sex partners. Under exploitation, do not have sex with a competent adult who consents, but is likely, under the circumstances, later to regret having consented. And under dignity, do not have sex if you believe doing so would undermine your self-esteem or make you unwell or unhappy. Let us take a brief moment now to reflect how we as a society can better act upon these important principles. As to noticing and calling out the other fine qualities that all women, including sex workers, have besides their physical characteristics, let us all endorse this point. I hope that the brief thumbnail sketches I offered in part 3 of the women that I've recently known that have sex for money served that end. Other clients frequently find opportunities to sing the praises of sex workers, and such praises very often focus upon the attitudes, brains, and personalities of these women rather than on their physical characteristics. Certainly, we would all do well to promote well-rounded ambassadors of the industry to shift the public's focus from the physical bodies of sex workers to their fine, unique qualities, and above all, to the immense humanity and compassion that is the hallmark of their important vocation. On avoiding prospective regret, we have, as mentioned, our 3-point plan set out in part 6 of this series. Finally, it is easy for all of us to endorse the importance of individuals exercising choices in full command of their own dignity. These surviving principles fall well short of anything like a moral injunction against contemporary sex work as a whole. The others are very unlikely to attract much serious or popular support as socially enforceable rules. None are fit objects for legislation in and of themselves, or as substantial and pressing justifications for laws that would infringe upon individual liberties. All are the province of our private philosophies and moral consciences, even as a few of them may quietly motivate us as individuals to seek important changes in our world. At a moment such as this, as it comes under such a grave and clear assault in our country, it is important to remind ourselves of the essential foundations of our tradition of Western liberalism. And so let us turn now to one of the greatest political theorists of all time, to John Stuart Mill, in his famous essay from a few years before Canadian Confederation, entitled On Liberty. And I quote, "Different persons also require different conditions for their spiritual development, and can no more exist healthily in the same moral than all the variety of plants can in the same physical atmosphere and climate. The same things which are helps to one person towards the cultivation of his higher nature are hindrances to another. The same mode of life is a healthy excitement to one, keeping all his faculties of action and enjoyment in their best order, while to another it is a distracting burthen which suspends or crushes all internal life. Such are the differences among human beings in their sources of pleasure, their susceptibilities of pain, and the operation on them of different physical and moral agencies, that unless there is a corresponding diversity in their modes of life, they neither obtain their fair share of happiness, nor grow up to the mental, moral, and aesthetic stature of which their nature is capable." Democracies have long been challenged in respecting individual diversity because of the common proclivities of the meddlesome majority. Again, to John Stuart Mill, and I quote, "The general average of mankind are not only moderate in intellect, but also moderate in inclinations. They have no tastes or wishes strong enough to incline them to do anything unusual, and they consequently do not understand those who have, and class all such with the wild and intemperate, whom they are accustomed to look down upon. There is no more inviting field than the moral and prudential improvement of our fellow creatures. These tendencies of the times cause the public to be more disposed than at former periods to prescribe general rules of conduct and endeavor to make everyone conform to the approved standard. And that standard, express or tacit, is to desire nothing strongly. Its ideal of character is to be without any marked character, to maim by compression every part of human nature which stands out prominently and tends to make the person markedly dissimilar in outline to commonplace humanity." When we fast forward 100 years to the early 1960s, we find the same perennial debate still underway. But now, finally, it was clear that those seeking to impose their morals on others with the law and the police were close to throwing in the towel. For our purposes, it is interesting to observe that even the famous pretentious conservatives in English political discourse acknowledged that directly legislating morality could not proceed without what they termed an overwhelming moral majority. H.L.A. Hart of Oxford, one of the most influential legal scholars of the 20th century, was a primary antagonist and the victor in this debate. His work, Law, Liberty, and Morality, is available to this day in virtually every library and is taught still in many law schools. And I quote, "It is important for the understanding of Stephen's views on the legal enforcement of morality to notice that he, like Lord Devlin, assumes that the society is marked by a considerable degree of moral solidarity and is deeply disturbed by infringements of its moral code. For Stephen, you, quote, cannot punish anything which public opinion, as expressed in the common practice of society, does not strenuously and unequivocally condemn. To be able to punish, a moral majority must be overwhelming." In Canada, we still await the release of any public opinion data that would come close to substantiating that such an overwhelming moral majority exists for the current government's adventure in the curtailment of personal liberties. What you certainly cannot do with propriety, even for the blowhard conservatives of yore, is to stand up and claim the status of a wise person, or perhaps in our age, the self-deputed representatives of one of the two genders, and propose that the government legislate on the sort of pious and obscurantist moral concerns that appear in the preamble to Bill C-36. Conservatives such as Lord Devlin, in any case, were crushed in this debate 50 years ago, and in part, that is why we no longer imprison homosexuals for having anal sex, and why we later repatriated our Constitution with a Charter of Rights and Freedoms. Hart acknowledged that public nuisances were sometimes a legitimate target for state intervention. In some cases, he gave the example of legal polygamous marriages as distinct from informal marriages of folks living under the same roof. The law may seek to protect frail members of society from shock or offense to feelings caused by some public display, in that case deemed analogous to loud music being played late at night. But any such protection is not premised on moral argument, and it cannot extend to what individuals do in private. The nuisance aspects were by and large the concerns that were found for the reform of the laws governing sex work during the 1980s, the ones that produced the communication-oriented laws. As it played out, in that instance also, the laws introduced were too poorly thought out as to their effects. inhibiting communication, drove the field underground, eliminated client screening, and directly led to unspeakable tragedy and eventually to the self-destruction of that legal regime. So now, with that one slender thread of nuisance cut, the government is desperately casting about and reaching beyond anything that has been considered for at least half a century a reasonable legal basis for such intrusions. The one vestige of the nuisance rationale found in C-36 is communicating around children. As an aside, I'll say that I don't necessarily oppose the communicating near children provision if constructed on a nuisance foundation. However, the law to avoid disproportionate effects needs to be explicit in defining times of day by which it is assumed that impressionable young children will be safely in bed and asleep, and therefore not exposed to what takes place on the streets. As the expression goes in another context, share the road. However, in banning online advertising for sex work on Backpage and on other forums, and in criminalizing clients, Bill C-36 reaches well beyond public nuisance to interfere with the private behavior of consenting adults explicitly on the basis of deeply contested moral arguments. The crisis in plural liberal values in Canada associated with the introduction of Bill C-36 is not limited to the text of the legislation itself. We also have major problems in the surrounding political discourse. Let's look at one of two primary concerning examples. In English, the colloquial expression mealy-mouthed implies unwilling to state facts or opinions simply and directly. And this certainly applies to the case of the use of the slippery concept degrading in a political debate concerning sexual services. Because degrading carries a double meaning in this context, and so it obscures rather than clarifies the rationale for this legislation, and it permits the stealthy injection of inadmissible considerations. In part 5 of this series, we dealt at length with the large gaps in the current state of knowledge concerning any impacts on health and wellness of contemporary forms of sex work, especially those conducted in private, more secure environments. And in an earlier segment, we reviewed Bernstein's assessment based on years of field research that there appeared little evidence to justify blanket assessments of this nature. So degrading, in the word sense of causing the deterioration of an individual's health and well-being, would appear, based on the current state of knowledge, to form a gross empirical overgeneralization, and certainly a totally unfounded basis for interfering with private sex work via banning various advertising forms. If we turn to the other sense of degrading, the value judgment, that sex work is dishonorable or shameful, making a person's life less admirable, we have in this case a serious breach in the course of political debate with a reference to an inadmissible moral argument. By the lights of our liberal traditions, using a word that contains such an implication is severely offside. Without exaggeration, one can say that it is severely degrading, in both senses of that word, to a Western liberal democracy to have that term crop up in the context of the official political discourse on sex work. John Rawls again, via de Marneff. Quote, "Justice's fairness requires us to show that modes of conduct interfere with the basic liberties of others or else violate some obligation or natural duty before they can be restricted." End quote. Rawls takes this to rule out the proposition that, quote, "certain kinds of sexual relationship are degrading and shameful," end quote, as a reason that can justify the government in limiting individual liberty. Turning now to Ronald Dworkin, another leading light of Western liberalism, and I quote, "A community might think that the conduct it outlaws, though not against justice, is demeaning or corrupting or otherwise bad for the life of its author. Liberal equality denies the legitimacy of this reason for outlawing conduct. Let's make one thing clear. On moral matters, refraining from state coercion does not imply being silent and indifferent. As Hart puts it, argument, advice, and exhortation are perfectly acceptable, but punishing to deliver a message is not. And I quote, "The idea that we may punish offenders against a moral code not to prevent harm or suffering, but simply as a means of venting or emphatically expressing moral condemnation is uncomfortably close to human sacrifice as an expression of religious worship. What is meant by the claim that the punishment of offenders is an appropriate way of expressing emphatic moral condemnation? The normal way in which moral condemnation is expressed is by words, and it is not clear if denunciation is really what is required, why a solemn public statement or disapproval would not be the most appropriate or emphatic means of expressing this." On June the 16th, 2014, Bob Deschert, the parliamentary secretary to the Minister of Justice, made a truly extraordinary statement in the House of Commons that began with the words, "Bill C-36 seeks to denounce and prohibit the demand for prostitution." I want to isolate and take issue specifically with the objective of quote-unquote denouncing prostitution via this legislation. If you believe you have a valid ethical case against prostitution per se, that as a philosopher king you have something you'd like to say, you go right ahead and make your case. I personally am extremely skeptical that such a case can stand moral, let alone legal scrutiny. As noted in this segment, I believe that the moral propositions put forth in the preamble are utterly vacuous ethically. But you feel free to exercise your free speech rights to make that case. Write an article on the op-ed page of Canadian newspapers telling me why you personally believe I should not share financial resources with a casual sex partner on agreed terms. Go wild, and good luck. I do think you'll need it, because if you reflect deeply on everything I've presented in this series of presentations, you will recognize that you are carrying a big, empty briefcase on this matter. But regardless of those intellectual efforts, which I think will be in vain, what you may not do in our society is to punish me with the law in order to denounce me morally. If that is your goal as a legislator, you're living in the wrong country. And there is at this moment an impressive new Islamic caliphate taking excellent shape in northern Iraq. You really ought to consider signing up to be a legislator there. Catch the next flight out, please. Look, all joking aside, this issue takes us to an extremely dangerous rocky ridge. On one side is one of our deepest commitments as a society, to profound respect for the freedom and liberties of individuals, the commitment that inspired Pierre Trudeau's repatriation of our Constitution with its Charter of Rights and Freedoms. On the other side is the repression and compression of private human life in the name of a politically led spiritual cleansing of just the sort that animates Islamist jihadists around the world, and in a different form that George Orwell warned us about in his literary dystopia, 1984. The opposite of liberal pluralist is not conservative, but rather authoritarian, intrusive, and repressive. Do not mistake the debate over C-36 for garden variety differences in preferences between social conservatives and secular liberals. This is an issue that engages the fundamental political and legal values that separate our modern plural nation from authoritarian police states. To the members of Parliament, Canada is a constitutional democracy, and our Constitution deeply commits us as a society to respect individual rights. These rights do not inhere in the majority meddling in the private, self-regarding conduct of minorities. Rights are born by individuals invested with dignity to make certain private decisions of their own volition. If the right to decide with whom to have sex and under what conditions is not one such decision, Lord help us, because a new and dark day is upon us. You are reminded of your oath of office, its substance and significance. Bill C-36 is an absolute abrogation of your most solemn obligations. Government in Canada is not designed to be a tennis match between the judiciary and Parliament. The Canadian Charter of Rights is not solely the province of courts. It is the fundamental law governing our society, and it is incumbent upon Parliament and you as a member to observe its spirit and letter in contemplating new laws. Do you not recognize and accept your fundamental obligation to uphold the Constitution of this great country? Are you so illiterate in the Western tradition that you are ignorant of what is the meaning and value of liberty? What could your true theory possibly be? I would suggest to you that with this law, as soon as it is struck down, if not before, you will appear for all of subsequent Canadian history as populist flunkies, the Parliament that fell asleep while guarding essential elements of our freedom and liberty. History will not remember this as your finest moment. It will record this as a breach of the basic expectations placed upon you. It will record this as the moment in which, for ignorance or gross political motives, you effectively suspended the core legal and political values of this country. If you are a Canadian MP, a federal policy advisor, or, God forbid, a Department of Justice lawyer, and are discovering the meaning and substance of Western liberalism, or even the interpretation of our charter for the first time via this presentation, it is truly urgent that you undertake a course of self or group study to inform yourself of the basic political DNA of our society. I've gathered on the next slide a few of the introductory and most important sources referenced here that you should be able to cover off over the course of a few focused days, which may be all the time you have to reconsider your views on this issue. In the event many of you find yourselves in the same position, I would suggest that you immediately organize one or more parliamentary book clubs to meet every few days for the next short period to read and discuss this literature. So here you go, an emergency parliamentary summer reading list. Have a read. Now, we'll let members of Parliament with their special needs work on catching up. In the meantime, the cure for this infringement on liberty and on freedom of expression is simply more free expression. This repressive program calls out for inspired, artistic, and civic political expression. And so let me put the call out. Aspiring short film directors, visual artists, photographers, and rap and pop artists who share my concerns could immediately consider developing transgressive works that treat subjects such as a lone sex worker who had formerly worked in an in-call, forced into the street by the ban on advertising, cornered by a predator in a dark alley. A solitary, disabled client remembering a kiss from a sex worker and the tears of gratitude that on that occasion rolled down his cheek before criminalization. Naked lovers embracing, terrified as a police tactical unit descends. Partially naked, traumatized, middle-class men sitting sweating profusely, heads and hands, in the back of a paddy wagon. Or suicide aftermath, a man hanging from a rope, indictment at hand, after having been outed by the police for having paid sex. These are just a few ideas. Clearly you will have more and better ones. For those politically inclined, including allies inside the House, I would advise the development of and advocacy for amendments, a time-honored and constructive form of intervention in a debate such as this. We need to find wedges that we can use to prop open the door to conversations all over this country during the coming weeks and months. If you undertake this exercise yourself, you'll find that it's easy to develop ideas. Here are a few that I came up with very little brainstorming on my own. Feel free to take these, modify them, make them better, make them your own. The Back Pages Come Back Amendment. Strike out the ban on classified display and banner online and print advertising, which undermines safer and more private, more self-regarding forms of sex work. The Sessions exemption, named after the recent feature film. This would exempt disabled clients whose use of paid sexual surrogates reflects their only realistic expectation for any partnered sex life. The Female Client exemption would exempt female clients of male workers because logically their transactions must contribute in sex work to restoring equality, a value referenced absurdly in this context in the preamble. The True Friends exemption would exempt lovers who have previously met at least twice and who swear a standard affidavit before a witness declaring that their relationship is a true friendship and that any money exchanged is a gift. The Certified Organic and Free-Range exemption would exempt clients of sex workers who meet certain standards, including no history of substance abuse or homelessness or other acute problems, and who sign an affidavit filed quarterly attesting no exploitation or coercion. The Secure and Progressive Establishment exemption would exempt clients and managers or owners associated with a site that provides security and monitored surveillance and maintains an excellent safety record, fully protects a sex worker's rights to choose her clients. The Fast Asleep exemption for conducting sex work on the streets during hours when children may be assumed to be in bed and asleep, and therefore not exposed to unwholesome influences. The Medicinal or Therapeutic Sex exemption for clients with a doctor's note attesting to the importance for the client of legitimate health benefits from sex sought by the client. The Bartered Sex exemption would exempt individuals who provide consideration for sexual services in kind, such as free travel or expensive jewelry. The Sugar Daddy exemption would exempt clients who pay a generous fixed monthly stipend to an individual in exchange for quote-unquote free sex. More seriously, the Facebook First exemption would exempt clients who have disclosed their actual identity, including recent photos to a sex worker before they first meet, implying that the worker exercises fully informed and meaningful consent and choice in selecting and screening the client. And finally, and perhaps most fundamentally, the Preamble Doublethink Amendment, in honor of George Orwell, strike out the references to a problematic moral philosophical doctrine imported in the preamble in these terms: objectification, commodification, exploitation, and dignity. Apart from advocacy for these and other amendments, we must also advocate for a reference to the Supreme Court for this legislation before it is placed in force. In the event that Bill C-36 is enacted and criminalizes clients, there will be those who will need and deserve our support. Clients will, of course, be charged and summoned to court, and on a monthly basis, perhaps the first Tuesday of the month after work, those who have been charged should assemble with all of their supporters outside the local courtroom and recite, "We gather here today as persons of conscience. We respect the right of women and others to choose on their own terms to be with us. We shall not be humiliated by a repressive, intrusive state, and we shall overcome." If you share my convictions, I hope that you'll consider taking the following pledge. As for me, my convictions are so settled on this after many days and nights studying and contemplating this issue that I personally will take this pledge before you right here and right now. And so I do declare, God help me, I believe there are some issues that test the defining political values of a country, and specifically its commitment to profoundly important individual liberties and freedoms. I hold in good conscience and upon deep reflection that Bill C-36 is just such a case. I solemnly pledge that I shall never again vote for any individual member of Parliament who at third reading fails to cast a vote against any bill that criminalizes the purchase, sale, or advertising of the sexual services per se of freely consenting, competent adults, so long as I shall live. My friends, this brings us to the end of this presentation and also to the end of this series. I want to thank you for your attention and time to this point. I know it's been a long journey through the many related aspects of this issue. I'd like to close this series where we began in the introductory segment with a little historical perspective. The issue before us today is nothing less than the struggle of a generation to live according to our own lights and for justice based on fundamental norms of our constitutional democracy and of the Western liberal tradition. Previous generations, those on the scene in the 1960s and 70s, could fight on behalf of the rights of oppressed racial minorities, women, and gays and lesbians. For those who desire to live now in a pluralist and free society with private lives free from interference from an intrusive state, this may be the struggle of our generation. I hope you'll find a way to join it. Thank you.